All right, good afternoon, everyone. We are going to go ahead and get started with our webinar today. Just as a reminder, as always, these webinars are intended for educational purposes only. And while we do hope that you learn new information, the trainers that present these webinars are not attorneys. Therefore, all information provided during the presentation and the Q&A session should not be construed as legal advice. All right, now that that is out of the way, good afternoon, everyone. My name is Brianna Grimes, and I would like to welcome you to our webinar today, where we're going to talk to you about understanding your employee handbook. And because we get so many questions on employee handbooks and we do so many handbook reviews, we've actually broken up this webinar into a three-part session because there are a lot of parts to an employee handbook and we get a lot of questions. So we wanted to make sure that we were able to address a lot of the frequently asked questions that we get, as well as break it up into three bite-sized chunks that are easier to process, rather than doing a very long webinar all in one sitting. So if you do have any questions during the presentation, please feel free to type them into the question box and they will be addressed during the Q&A session at the very end. Now, with that being said, well, let's go ahead and take a look at our content today. So today we're going to be talking about specifically the legal requirements and employee handbooks and the different dynamics between the legalities surrounding employee handbooks, because there is a lot of confusion when it comes to legal requirements and handbooks. And specifically, we're going to be talking about the legally required policies. And these include some policies like the Atwill Notice, Equal Employment and ADA statements, Immigration Compliance Statement, employee classifications, lactation accommodation requirements, sexual and other forms of harassment policies, state leaves, and state leaves. And then we will end, like I said, with the Q&A, and I am open to any questions that you may have, so please feel free to type those into the question box throughout the presentation if you have questions. All right, so before we jump into going into specific policies, I want to walk you through a diagram that I devised because it's really a good visual on understanding the legal requirements in employee handbooks dynamics. Each of your organizations are going to fall into one of the two categories I'm about to explain to you. And we're going to be talking about one of the categories very specifically today. So in order to avoid confusion, I just want to illustrate kind of this dynamic so that way you can kind of understand how employee handbooks function in the legal realm. So first and foremost, I want to clarify something that confuses a lot of employers. So I want to start with this statement. Employee handbooks are not legally required, okay? You do not have to implement a handbook if you don't want to. They are 100% optional. However, if you choose not to have one, you are still legally required to comply with state and federal laws that pertain to you. And just know that without written documented policies in place in the form of a handbook, courts tend to favor employees in the event of a claim because there is no written documented stipulations or expectations. So keep in mind that choosing not to have a handbook is a choice, but it comes with increased liability. So again, you have a right to not have a handbook, but just know that it comes with risk, a higher level of risk, I should say. Additionally, it can be very difficult for employers without handbooks to enforce undocumented performance or attendance-based policies because these are not mandated by state or federal law. Now, what that means is that you have the potential for more post-termination claims from employees because you don't have an enforceable written policy on file that governs their behavior during employment. If you don't have a written documented attendance policy that you are practicing across the board for all of your employees and you fire someone for attendance, there's a very good chance that they decide to seek out an employment lawyer and file a claim for wrongful termination because there was no policy or expectations documented. So just that's something to keep in mind on the not having a handbook side. Now, for the purpose of this presentation today, I am going to be talking about the legal requirements of employers who choose to have a handbook. So we are not going to be talking about the group of companies that don't have handbooks. I am going to, throughout the three-part session, assume that all of you have chosen to have a handbook in your employment process. So that is the assumption that is going to be made throughout this presentation. So with the assumption that you are choosing to have a handbook on file, means that you are legally required to follow the policies, same as if you don't have a handbook, but you are also legally required to follow any policies you decide to include in the handbook that are not necessarily legally mandated. Now, this is a federal law, so if you have a handbook on file and you've implemented it with your company, you are legally required to follow your own policies, even if it's something like PTO. The government does not regulate PTO in terms of requiring employees to offer it. But if you say you're going to offer 2 weeks of PTO to your employees and you deny employees the ability to use their 2 weeks of PTO, they can file a claim against you because you are not following your own policies. So keep that in mind as we're talking about the legally required policies today that are federally and state mandated, as well as the legal obligations that you have as to following your own handbooks. Additionally, based on this assumption, you are choosing a handbook. We will be discussing what policies are legally required to be in the handbook if you choose to have one. So today's presentation is going to be entirely based on if you choose to have a handbook, these policies have to be in your handbook to be compliant because of the types of policies they are. And so that is kind of the dynamic we are going to cover today. Now, one of the biggest questions I get on handbooks is, well, if the handbook is not legally required, how can these policies be required? It doesn't make sense. And really, the diagram kind of illustrates that. But think of it like, I know this is more a little bit controversial topic, but think of it like gun ownership, right? We have a right to own a gun. You do not have to own a gun, but if you do, you have certain rules you have to follow if you own a gun. Employee handbook is the same way. Weird analogy, but it makes sense. So I'm going to go ahead and we're going to start talking about the legally required policies for employee handbooks. All right. So this week in the part one, like I said, we're going to be talking about legally required policies. Should you choose to have a handbook, needs to be in this handbook. So legally required policies are policies that are stipulated by either federal or state law, and employers have a legal obligation to provide some sort of notice or statement to employees regarding these policies. So the employee handbook is one possible form of the notice. There may be other notices that you legally have to comply with. We're not really going to talk about those today, but just to give you an example, one example would be like a labor law poster. So labor law posters are required to be posted, and they may have notices like minimum wage, workers' comp, and whistleblower protections. Some of the labor law poster notices may duplicate or be very similar to employee handbook notices. So think of the employee handbook as a vessel for the compliance of these notices, providing this information to your employees. Another example could be onboarding documents. So a lot of the times when we're reviewing handbooks, onboarding tends to be the best time to send employees documents, and a lot of companies will not only have a confidentiality statement in their handbook, but they may have a confidentiality agreement. So this is another example of where some of these legally required policies may duplicate in other forms, but just keep in mind that they have to be in your employee handbook as well. All right, so that being said, we are going to review a couple of different policies that have legal notice requirements to include in your handbook to ensure your compliance. Now, this is not going to be an exhaustive list today, but I am going to talk about kind of the main policies that are legally required and some of the ones that give employers the most trouble. So the first policy we're going to talk about is the Atwill Notice, and I get a lot of questions about the Atwill Notice because a lot of employers misunderstand what it means, and rightfully so. It can be very confusing. Usually, I only get questions on this type of policy when an employer is getting ready to fire someone. So it's kind of a little too late to understand this policy. So I'm hoping this helps provides a little bit of light on the subject. So generally, it means that the employee or the company can terminate their relationship at any time for any reason without notice. However, keep in mind that every termination comes with some level of risk, regardless of the at-will doctrine, and you as the employer take on that risk. Depending on your state, your county, your municipality, even your industry, the courts can determine that some terminations are unlawful based on the legal interpretation of what they call 3 exceptions to the Atwill Doctrine. These 3 common law exceptions to the Atwill Notice are as follows. The first is public policy. This exception states that termination is wrongful if it goes against a well-established public policy of the state. This exception is accepted in 43 of the 50 United States, and many states have expanded this exception to very state-specific requirements. This is why many HR professionals will encourage you and managers to have a business reason for any termination that you decide to partake in order to defend against a public policy claim. It's virtually impossible for any employer to know every single public policy in their specific state, as well as every court case that has ever weighed in on those public policies. So unless you want to pay hand over fist in legal fees, the least expensive route that we always recommend is that you make sure that you have a business reason or an HR approved reason for termination every time. Now, the second exception is something called an implied contract. And this exception states that the termination is wrongful if it violates an implied contract between the employer and employee. Note that this says implied, not documented. If there is reasonable evidence to support that any implied contract existed, the termination can be wrongful for this employee. For example, a few years back, the structure of what employers use now as offer letters changed. One of the circuit courts on the federal level found that an implied contract existed when an employer provided the employee's annual salary on their offer letter. The argument was that this created an implied contract of a minimum of 1 year of employment. So if I receive my offer letter and they just hired me for a job and they're saying on my offer letter, your salary is going to be $65,000 a year, that became interpreted from a legal standpoint as an implied contract that you were guaranteeing my employment for 1 year because that's how you calculated and expressed my pay to me when you gave me the offer. Now, because of that court case, most offer letters will state the biweekly or weekly pay amount and the total annual compensation. So now my offer letter would say, we are going to pay you $60,000 a year, equating to $1,200 or whatever the amount is per biweekly pay period. So now it's saying this is your weekly or biweekly pay period based on how our pay is practiced to the total of approximately $60,000 a year. This basically got rid of that implied contract statement. So it's little nuances like that when it goes to court can all of a sudden become an implied contract. And again, there was no definitive contract there. The company never promised that person a full year of employment, but that one sentence in the offer letter was interpreted as an implied contract. And finally, the third exception was a covenant of good faith. And this is the least common exception, but it's only recognized in 11 of the 50 United States. This exception prohibits terminations that are made in bad faith or motivated by malice. Another way of saying this is that it's been interpreted to mean that employers have to have some type of a just cause to terminate an employee, meaning that you can't fire someone just because you don't like them or it isn't working out or they just don't fit the company culture. You have to have a documented performance or behavioral reason for terminating them. So a lot of the times when you guys reach out to either Kathy or myself with termination questions, this is what we take into consideration. And this is why a lot of the times, depending on the amount of risk you as a company are willing to partake, we're going to give a more conservative answer in helping you decide whether or not to move forward with termination, because like the slide says, every termination comes with some level of risk. And the Atwill doctrine is not as cut and dry as most employers probably wish it was. At one point in time, when the Atwill Notice first came around, it was absolutely cut and dry. Anyone can terminate for any reason. But unfortunately, over time and with the more complexities of the legislative arena that we have experienced in the past couple decades, it is not as cut and dry. So keep that in mind as you are deciding when and how to terminate an employee. And this Atwill notice has to be included in your handbook to notify employees of their rights. All right, another policy is the Equal Employment Clause and ADA accommodation statements in your handbook. Now, these statements provide notice to employees that you follow non-discriminatory hiring and employment practices. You may also see similar statements like this on job postings or employment applications and even in job descriptions, depending on what is required of you. There is never too many places to put these types of notices because of the severity of violations under the EEOC and the ADA. Additionally, the ADA statement specifically should also include an accommodation notice of internal processes, meaning that you need to provide employees with a general idea of how to go about requesting an accommodation, because if they have a disability as defined by the ADA, they have a right to an accommodation. If you do not have a process in place or you don't notify employees of their rights and abilities to request this accommodation, then you're not in compliance with the ADA. And if their lack of ability to get an accommodation through your company is a contributing factor to a termination, you can also be held liable for a wrongful termination under the ADA, and it will be considered a discriminatory termination. So you need to have these statements of rights and inform employees of their rights, as well as have a process in place for ADA in order to be compliant. Just to give you an idea and some context, ADA claims have increased over 20% from 2018 and are steadily going up. Many employers don't understand their obligations under ADA, and many of them find out when it's too late because they get hit with a lawsuit for violating the ADA rights. Having these types of statements in your handbook can help mitigate that risk and provide some key information that employees have a right to. All right, next we're going to talk about immigration compliance. So immigration compliance is a policy that I don't see too often in handbooks that I review, but I always add it in during my review. A lot of employers think that immigration compliance primarily deals with things like work visas or hiring employees from other countries or students that are here on a student visa. Compliance actually starts with the I-9 process. A lot of people don't think about that, but the I-9 process is an immigration compliance law. And it really is meant to make sure that you are compliant with regulations surrounding what's going on in terms of the United States immigration policies. So I-9s are used to verify the identity and employment authorization of individuals hired for employment with your company. That is why you need to have one for every single employee on file. This process must be completed within 3 days of hire. This includes both the verification of the documents and the completion of both pages of the I-9 form. Now, there has been some leniency with the COVID-19 pandemic pertaining to verifications of employment documents for any companies that began working from home. However, if you have returned to the office since hiring an employee, you have an obligation to verify their documents in person upon the return to the office per the ICE guidelines. So keep in mind that the exceptions that were made were only temporary, and employers should expect to see an increase in immigration audits in the next 12 to 18 months to enforce that. Some companies were even making edits to their employee handbook that they were not going to be processing I-9s until they return to the office. And if you have anything like that in your handbook or you made any of those types of edits, please get rid of them because they are not compliant and they were only temporary. So you do not need to have those types of temporary policies or exceptions in your handbook. They're not necessary. Now, a typical immigration handbook statement really just reiterates that the employer is adhering to their legal obligations under this law and that they are processing I-9s properly and that they have them filed and that all documents are viewed within the first 3 days of hire. That's really the expectation as far as this policy. All right, next big one we're going to talk about is employment classifications. So employee classification is another big one, and I get a lot of questions on this one as well. So this section is required to be compliant with the Fair Labor Standards Act, and what they regulate is properly classifying your employees. And this is a huge compliance piece that probably a lot of you, I'm going to tell you right now, are probably not compliant. You may think you are, but most employers mess up their FLSA at one point or another in their life cycle of their company. Now, employers are legally required to notify employees of their employment status. Typically, this is found in the offer letter. You let them know if they're hourly or salaried, and you have to let them know what that status means. Many employers include the status notice, like I said, in the offer letter, but they typically don't define that classification in the offer letter. Typically, you just get a notice, hey, you're hourly, hey, you're salaried, whatever it is, but there's no definition. An employer should have some type of definition, not only the number of hours that are expected for that classification, but also what benefits are available to that employee and what the expectations are under that classification, because those can vary from employer to employer because there is flexibility under the FLSA in some of the classifications. Now, additionally, employers should avoid making up classifications. It kind of goes without saying, but I've seen it happen before, and I've reviewed quite a few handbooks that people had classification statuses that just don't exist. So unless they are recognized by the FLSA, they can't be in your handbook. You can't have a temporary salaried employee that doesn't get benefits. That's not a thing. So please don't put that in your handbook. Also, one additional benefit to having this outlined in your handbook, is that it creates a tool for your employees to understand their classification and their benefits. So rather than having a filter, have to filter a bunch of questions about what level of PTO they fit into or what benefits they're eligible for, the handbook really has it all, and it becomes a one-stop shop for employees. And that's good. That's what you want the employee handbook to be, is that one-stop shop for employees to get this information, because if they're using the handbook a lot and you have these legally required policies in there, this adds that extra layer of protection to your organization. Each employee gets a handbook. They get a digital copy of their handbook emailed to them on their first day. They refer to it all the time for PTO. So thought process goes that this person has access to other things too. They would know about their ADA rights. They know about what leaves they're eligible for. So you want them constantly referring to and using the handbook as a resource, because again, that adds extra protection for the company that they have access to this information. Whether they choose to use it or not is not your responsibility. You can give employees information and they can choose not to use it. I can tell an employee, you're eligible for FMLA. Here's how you sign up. Go ahead, sign up here, turn it in, turn your medical certification in, you get your leave of absence. If they don't do it, that's not liability on the company. So as long as you are providing them with the information that you are legally required to provide to them, you are compliant. All right, next one we're going to talk about is a lactation accommodation. And a lot of employers get confused by this because they assume that this ties in with FMLA or pregnancy leave or even state leave laws, and it doesn't. This is actually a completely separate law, and it is governed under federal guidelines. So most employers don't have this in your handbook, and if you don't, you definitely need to add it, because you are legally required to notify employees of their rights under the break time for nursing mothers law, which dictates the lactation accommodation. Now, if it's not included in a handbook, it is highly unlikely that you have it included anywhere else for the employee to access, which means you are definitely not compliant because, again, you're not providing them the information that they are legally entitled to. Like I said, this is a federally required law, and it does dictate both the amount of time nursing mothers can take, as well as where the nursing can take place, as well as employer obligations. You have to provide a certain type of environment for women to express breast milk, and it has to meet certain requirements that are stated in this policy. So the location must meet federal requirements and possibly even state requirements, because state requirements do expand this law from state to state. So you will need to modify the federal policy in your handbook to match any state guidelines that have been modified in your specific state. Also, this accommodation must be made for up to 1 year following the birth of a child. A lot of people tend to assume that it's only for a couple months after the child is born, but under federal law in your policy, it has to state that this accommodation may be made up to 1 year. And employers are obligated to follow this law in regards to how long that can be accommodated. All right, next we're going to talk about sexual and other forms of harassment policies. Now, included under this umbrella is bullying, abusive conduct, violence, and things like that. A lot of employers do get confused on this one because harassment does have a lot going on, not only from the federal level as well as the state legislative level, but there's also a lot of sections to this policy, and this tends to be one of the longer policies in handbooks. So it can get a little daunting when you're reading over it to make sure you're compliant with every single piece. So let's break it down a little bit for you. So sexual and other forms of harassment are illegal under federal law. Kind of should be a given, but I wanted to make sure that we were all on the same page. Federal law does not require, however, a policy on harassment. Again, similar to the handbook, you can choose, but most state laws require a policy. If you have a state that has any type of legislation on harassment or bullying behaviors, and courts actually favor employees with a policy and training in place, even if it is not required. So what that means is that if you have a policy in place in your handbook and you do harassment training, maybe just as for new hires, once when they start with the company or when managers get promoted, then there is evidence that your company took good faith measures to prevent harassment, and you'll be more likely to reduce cost of harassment claims depending on the claim, if you ever get hit with one. Basically, these are preventative measures against harassment from occurring as well as from claim damages. So again, having a policy in your handbook, it doesn't cost anything extra to have it. Harassment training, as far as in comparison to what harassment claims will cost you, are pennies on the dollar. So as far as preventative costs go, these are probably the most effective preventative dollars you can spend for your company, especially with the increase in harassment and bullying claims that have happened over the last couple years. On that note, another thing to keep in mind is that some states not only require you to have a policy in your handbook, but they do require harassment training. So you may not have the option, it may not be preventative, it may be a compliance piece for you and your organization. So you should definitely be familiar with whether or not your state requires harassment training. For your reference, I have put the states on the screen. So for example, in California, you have to recertify your harassment training for all employees every 2 years. And in Illinois, it's actually every year. So you can't just do the training one and you're done, depending on the state that you're in. And if you do need to get any training done before the end of the year, and this was a really good reminder for you, you can definitely reach out to me after this webinar, because Pay Entry is doing our last sexual harassment trainings of the year in September. So if you have anybody that needs to retake their certifications to be compliant with state law, let me know. We can get you enrolled in that class. All right, and finally, we're going to talk about state leave laws, and I'm just going to touch on this briefly because we are going to go more into this when we talk about benefits specifically, just because benefits is such a big section. I wanted a webinar kind of dedicated to that, and that will be in session 3 of this webinar series. But state leave laws, obviously, as their name implies, vary by state, and employers should be familiar with what leaves are required in your state. Some examples include things like volunteer firefighter leave, veterans leave, sick leave, witness leave, things like that. And those should definitely be in your employee handbook because, again, you have an obligation to notify employees of their rights to take leave. Now, some states even have differing jury duty and voting leave policies. So if you are a multi-state employer, don't assume that the laws you used for your headquarter state is going to be compliant across your company, because more than likely they're not going to be. There's a lot of variation in some of these leave laws across states. Now, for all of these state mandated leaves, employers are required to provide employees notice of their rights to take this leave. That's why this policy is required in the employee handbook. It's your obligation to inform employees of what is available to them to take protected time away from work for any of the reasons that are dictated under these state leave laws. And typically these are, like I said, considered a benefits, and they should be included in the benefits section of your handbook to be compliant. The only other kind of format I've seen is I've seen employers put these under a specific leaves section. So they will actually separate out benefits and leaves. If you're a multi-state employer or you're in a state like California that has a lot of leaves that they allow through the state, as well as, if you offer FMLA because you are large enough to be eligible for it, I definitely recommend separating out your leaves to a separate section because it can be a little intimidating for employees to go through a benefit section that's 20 pages long when they're only looking for the PTO policy. So sometimes breaking up those two is a good idea. But just remember that any state-specific leaves, regardless of whether you have, for example, if you don't have any volunteer firefighters in your company, that's fine. You still need to have this in your handbook in order to be compliant. So just kind of something to keep in mind with these types of leaves. All right, so as you can see, there are a lot of legal components to handbooks, should you choose to have one. Now, remember that the handbook is a vessel and you get out of it what you put in it. Employees use it as a tool for information pertaining to their employment. So you definitely want to make sure that they get the right information and that they get the information that you are legally required to provide them. So if you do have any questions, feel free to take this time to type them into the question box now, and I will answer them in just a second. But for any of you that are either thoroughly confused or thoroughly overwhelmed by all that information, and we're only in part one, and you're interested in having your handbook reviewed, Kathy and I review handbooks all the time. It's one of our most popular services. We do it all the time. We have some great policies that we can tweak to your organization. We're familiar with mostly all the state laws between the two of us. So definitely, if you're interested in a handbook or having your handbook reviewed and you'd like to get a price quote on that, please feel free to email me after this webinar or after the series if you want to sit through the whole series and then decide. That's completely fine. Also, as a reminder, this presentation is being recorded and it will be available to watch again. So to do that, you can visit www.payentry.com and hover your mouse over the top webinars tab at the top of the menu bar and click on the submenu webinars recordings. The most recent recording is going to be on top, and we usually post these within 24 hours. So by tomorrow afternoon, you should be able to review this again if you want to take a look at it. There's also a survey that follows this webinar, so feel free to leave your feedback and let us know if you have any suggestions or if this topic was helpful or if it wasn't helpful. Please let us know because we definitely want to get your feedback on that. All right, let me see if we have any questions at this time. Yeah, so with the email, when you guys get the confirmation email, you will get a copy of the slides as well. And you will get a copy of the webinar emailed to you as well. If you do not receive the slides, because I know sometimes they don't send for some reason, just hit me up, send me an email, and I will go ahead and email you the PDF of the slides. But they should come through in the confirmation email with a copy of the recording. And usually you get that within 24 hours, so you should have that by tomorrow afternoon as well. All right, well, there are no other questions at this time, but I'm always a resource. We're always available to you guys. Just to kind of give you a sneak peek, next week we are going to be talking about recommended policies. So these are not legally required, but these do add legal protections. So these are policies that we recommend you have in your handbook. And we're also going to talk about employer policy enforcement obligation. So we're going to dive in more to why you need to enforce the policies, how you need to enforce the policies, and why you need to edit your handbook frequently in order to make sure that you are following your own policies. So join us next week for part 2 of the employee handbooks overview, and we will see you guys next week. Have a great rest of your day.